Good morning, friends. Sat Sri Akal, Adab, Namaskar. This is my 200th video, and specifically because this was the landmark video in the number system 100, 200, I purposely picked up this video. This is a case of JHANSI where the President CANTT Board JHANSI filed a suit, a writ in the Allahabad High Court that no sales within JHANSI Cantonment in either of the registras 1, 2, 3 which were named should be done without an NOC from the department. Now, what is this case? I expected that somebody from JHANSI who considers them and who are, spreading themselves into this cantonment era, that they are quite educated. Why didn't they take a stay, or why didn't they go in for a LPA or an SLP against this order of the High Court? Now, this order is quite similar order to the order which happened in Varanasi. I remember we were in Varanasi, and one of the bungalow owners, now late, actually shared this with us, and I wanted him to share the writ with me, which he did not. He even attended our convention, but unfortunately even there he did not share this document with us. I don't know what the reason was. I really wouldn't be knowing how bungalow owners, they react to all this, why they don't share their documents or anything, which is very important in today's world. If we don't share our things, because I'm being very honest, nothing as a status can either of the bungalow owner or resident can change yours. Your GLR of everybody in the cantonment speaks either B3, B4. These are your classifications of land. Now, let's come to this case. So, this writ was filed, and in the opening para, it admits and it states that all lands within the cantonment are governed by old grant or leasehold rules or rights. So, meaning hereby that Government of India is the owner of entire JHANSI cantonment. And what are we? We are just holder of occupancy rights. So, the GGO 179/1836 is applicable on JHANSI cantonment. Under the CLA rules, Rule 15, which it speaks of, it bars the sale and proceeds without an NOC. This is 1937 CLA rules. Similarly, in the GGO, it has been written that any sale above 5,000 rupees, the GGO terms clearly say that a permission is required for the native. From whom? The Commander-in-Chief. Now, this writ number 12897 of 208, which was filed by the President CANTT Board Varanasi for obtaining a similar NOC condition, which was decided in October 2010 by the Allahabad High Court. So now, after this, nothing is left. Now, practically, whole of UP, whether it is Allahabad High Court, whether it is Madhya Pradesh High Court, any of these high courts, the jurisdictions have reached everywhere. So now in these cantonments 57, you cannot do sale purchase without an NOC, and NOC doesn't come, which most of us know. Whether you are a property in civil area, whether you are a property in bungalow area. Now the CO Varanasi claims in his letter of 2011 that under section 356 of the cantonment, the sub-registrar has to inform every doing. Absolutely right, because it says under this registration act, section of 356. So the department now knowingly is writing on the Varanasi judgment to the registrar JHANSI that no sale should be done under section 354. So a legal opinion has been garnered on it, And this legal opinion says that we need to get into some nitty-gritties about the actual order passed in the Varanasi case. So let us fabricate, or let us make a new writ and then finally take clarification from the Honorable High Court. So in this writ, neither the residents of Jhansi or Varanasi were made parties to. Nobody by himself came up. Instead, this bungalow owner in Varanasi was aware of this kind of writ. He had himself filed a similar situation, that the sale done for his own bungalow should be considered null and void because the permission or NOC was not granted by the department. You know, we bungalow owners, for sometimes for our petty gains, we actually kill the whole system into us. So now none of us, and I would rattle these Jhansi advocates and Jhansi learned luminaries in the cantonment issues, Mr. Takshi, no, what is his name, I'm forgetting, why at the back of us these kind of judgments are taken. Now there is a directive which has been sought in the Honorable High Court by filing in Magnanimous, that the respondents, now respondents are who? The UP Department Office of Registrar in the center of UP Lucknow and at various headquarters of the sub-registrar's power. So they say, the Jhansi president says, we have not filed any writ like this in any courts. There has no caveat been placed before it. And this entire writ is governed by GGO 179, Cantonment Code 1899 and Cantonment Code 1912, CLA Rules 1925 and 37. So this para speaks of Regulation 6, and I will just speak the major part of it. Condition of occupancy, that no ground. Transfer to native. Fourth clause, transfer to native when it is proposed with the consent of the journal officer to transfer possession to native, should the value of house, building or property to be transferred exceed rupees 5,000, the sale have been obtained through His Excellency in Commander-in-Chief. Now it is very important what this actually holds. GGO speaks. It says sale of house, building or property. So these three things have to be defined. Nobody is in the court to answer back to these statements. So the department is not mentioning the whole of the GGO. Why it is not mentioning? Because it suits them. So nobody moves on. Now whether Jhansi was a part of Bengal presidency, was it a part of Bombay or Madras presidency? Now what does section 280 of the Cantonment Act 1924 6? It simply says that the Cantonment Board or the Cantonment Act has powers to make rules. It was there in 1864 also, it was there in 1880, 1910 also. So this is nothing something rule. Now we must understand what in rules. Now we'll read sub-rule 2, sub-para A, the manner in which and the authority to which application for permission of occupying land belonging to government in the cantonment is to be made. So rules have to be made for those properties which belong to the government. So the minute we bungalow owners say that CLA rules are applied on us, we fall under this sub-para 2 sub-A, the authority by which permission may be granted and the condition to be annexed to the grant of any such permission. Where is that grant? So presumably admitted that we are a grant under which GGO 179. So we guys are so ignorant to our small rules what the Britishers made. None of us would subjectively read these rules and connive them with the happenings. 1924 came, after that CLA rules in 1925 came, after that 1925, 1937 CLA rules came. So what are we doing? So now if we pick up the rules now, what this writ is speaking, it speaks of Rule 3 of the 1937. It doesn't talk of the rules at all of 1925. It presumes those rules are finished, they are repealed. So now Rule 3 says how a GLR has to be maintained, whether inside the bazaar or outside the bazaar. It speaks of Rule 4, where the classification of land has been done as A, B, C. See, prior to 1925, there was no classification of land. Rule 6 speaks of what classification B holds. So we have 4 types of land in B: B1, B2, B3 and B4. What are we bungalow owners and civil area bungalow owners and leasehold? We are B3. Okay. Now going to CLA rules, going to the prescribed GGO 179, how the GLR is being maintained under Schedule 1 of the CLA rules. What does the GLR speaks? What does Rule 5 and 6 speak? How the classification and the definition of these lands have been subscribed. It speaks in their interest only. Now it says classification of A1 land. It is very clear. A1 means army, B means bungalow, C means cantonment. I've been always telling everybody on this. Now, A means active occupation of the army. So, what is the need of defining that whether A1, A2 or anything? But he says any land which is in the possession of the government and so on. So, it goes on. So, A1 land which is actually used or occupied by the military authorities for purpose of fortified barracks, stores, arsenals, aerodromes, bungalows for military officers. This is very important. Which are property of government, parade grounds, military recreation. So, A1 land even had bungalows. Now, A2 is land which is being specifically kept for military. So, this is temporarily in coming days may be required. So now here in this writ, the advocate of the President CANTT Board JHANSI is specifically defining specific military objections. Why? Because it knows it can be an objection. Then it even is defining military recreation grounds. Because they know there are golf courses made, there are horse riding clubs, there are swimming pools on it, and the CAG has committed these reports. If you go back to the CAG reports from 2009, which I have in my record, everywhere it is being saying misuse of A1 land done by the army. Now, army calls their golf course as training camps for whom? For officers? No, they say for everybody, from officers to Johnnies. How many Johnnies are golf course members? Let's know from your cantonment. So this is the problem, you know. Now it defines land in classified B, which is bungalow area. Lands which is actually occupied by War Department, administrations and European cemeteries or something, which are those graveyards and all. B2, which is actually occupied and used by control for departmental provision. These are those post offices, SP office, whether DC's office, telegraph office, any of these judicial rooms. Now B3 land, this is where it is defined. Land which is held by any private person under the provision of these rules, or which is held or may be presumed to be held under the provisions of the Cantonment Code 1899, 1912, or under any executive order previously enforced in 1899. So friends, there are two things which speak. It doesn't talk of GGO B3, it doesn't talk of anything confirmative, it says presumed. So, subject to conditions under which the central government reserves or have reserved to themselves the proprietary rights in the soil. What do you mean by have? This definition itself is a broken definition. But who will repeal or peel it? I want this bungalow owner, Mr. Bakshi, or what is his name, to actually, rip apart this definition and then see. So lands in B4, which does not include in any of the class, neither A, neither B, neither C. So what is it? It is freehold land. Or is it private land? It's very funny, if you read these CLA rules. Now, the advocate makes an observation that all lands within Jhansi cantonment boundary pillars belong to government, which it pleaded in the very first para. So, these presumptions are not rebutted. Nobody is coming to the court. Executive orders, nowhere it is written that GGO 179, which is considered as per a judgment of Allahabad High Court only, that all Governor General orders carry a force of statutory laws. But here it does not speak of that law at all when CLA rules in 1937 was being. So that means when the Britishers were making the definition of B3, the GGO was not a statutory law. What was it then? That's all we need to. But unfortunately, when we got independent, our courts under the 1915 and 1935 Government of India Act and the Constitution have merged all Governor General orders as to be a statutory law. Instead, the Britishers are writing it is not a statutory law. So, who's going to take all this? Now coming to what it pleaded in Rule 15 CLA rules. Sale of land prohibited for any purpose without the definite order of the central government is prohibited. One, the rule in chapter 5 not only apply to land placed under the management of MEO or the Defense Department letter number of 4th May 1938, see Rule 9, but also applies to mutatis and mundis under Rule 47 to land entrusted to the Cantonment Board, under Sub-Rule 5 of Rule 9. So, this Rule 15 is subjective to MEO as well as to the CEO. Now, who's filing this writ? It is the Cantonment President Board. It is not the MEO. So, is this writ to be made applicable on Jhansi Cantonment bungalow owners? Is a question mark. Here the advocate comes up with a half-truth. Does not speak of Rule 9 at all. It clearly speaks of the management of the land. Now, who has been assigned the management of lands of bungalow area, B3 lands or B4 lands by a letter of the army authorities, and who has been assigned these similar lands to the Cantonment Board executive officer? So, nowhere there is any statement on this. So, these are Rule 9 speaks of these two parts. Under various authorities of 1942, executive letters in 43, how these rules were given. Now comes up Rule 43, which speaks of Rule 2 of CLA. Nobody has argued this. So, we need to wake up. Please. The department has not come with clean hands to the court. So, we only need to actually file a writ to the LPA or to the Supreme Court that why sales are being restricted in Cantonment. Now, in this writ, the advocate is even pleading a section of Contract Act section 23. Now, what considerations to the lawful, and it says that if any sale takes place between a contract which has been forbidden under the law by a policy. Now, this section clearly speaks of a law if there is a policy or an executive order, and then further on if there is a contract made between two parties. If you read this Contract Act, it is forbidden. Fine, agreed. But that has to be in an executive format, na? It is a policy making decision. So, has the government come out with a policy that they can, is a blanket ban on sales in cantonments? No, there is nothing like this. These are executive orders which the government in the various periods from 72 onward has been passing on. So, there is no law, there is no rule which bans the sale. But there is a public executive order, and under that order, you reach the High Court and garner a judgment in favor of you. Now again, Rule 354 of 206, it very clearly says that TPA Act's applicability stands on it. The sub-registrar powers are with the cantonment magistrate. Now 2006, even 1924, because in 1924, actually the sub-registrar powers shifted back to the DC of the cantonment. From 1864 to 1924, the sub-registrar and the sale and purchase powers were with the cantonment magistrate. Acceptable. Was the cantonment magistrate then taking permission from the commander-in-chief from 1864 to 1924? No. There is no authority, no letter, no executive which came in my research material that anywhere the cantonment magistrate was taking these kind of permissions. Whether the sale was below 5,000, whether the sale was between an army officer, British army officer's wife, or to the other wife, or from a wife to a native Indian, nowhere there is on records there is any permissions there. So now he talks of Registration Act 1908. This is what this 354 talks. Instead, actually the Registration Act of 1877 is also applicable on cantonments. So these immovable properties, these definitions have to be dug in from the TPA Act and from various articles in constitutional matters. So who will actually come up? One way 354 says TPA Act applicability stands and the Tahsildar is supposed to inform the DO or the concerned CO that there has been some transaction and sale, so the shift of ownership has taken place. Fine. But the advocate doesn't go into, why would the advocate of the government do this? So here is that Decorian thought that the entire writ is depending on the order of 2010 Varanasi. I am ashamed on Varanasi bungalow owners and residents. I've been yelling on to Mr. I can't name him, he's no more. But, for your personal gains, you kill everybody. And I know this Jhansi bungalow owners also, for their petty financial gains, they become advocates. They think they've learned the cantonment laws and the cantonment historical facts in a different way. But please, friends, please. So we need to understand what really happened at Varanasi. Why that case came up. Why the bungalow owner was entrusted that this order should be passed. Because lately by 2012 and 15, he picked up an order for his own bungalow that the sale done by him got on to be known to his family was an illegal sale and needs to be cancelled. Why did he ask for that? It's a very simple reason he asked for it. Because he was playing a fraud with the bungalow, the buyer who had bought the property. So please friends, we can very easily fight our cases. Everything is in order, everything is in place. It is only that we need to, if you watch my videos on cantonment cases, you will understand why am I saying these cases become very important. Why am I saying everything is very important? Because the Supreme Court or the High Court would interpret the laws of the nation. They will not read your plaint, they will not read your evidence, they will only read what actually the law says or what the CPC says. So please, this is an unbelievable judgment which has finally come across onto the whole of 57 cantonments. Whether you go to Pune, Sikandrabad, you have such educated people sitting in these cantonments. Pune, I just got on a week back that Pune bungalow owners are again harping on to file a public interest litigation in Supreme Court. For what? Please understand what is a pill. You cannot claim ownership in a pill. What are you trying to? You can only claim a directive. So how do you get a directive? That is the question. So directive can only be on evidence that there has been some fraud, that the documents are not produced to you or handed over to you. So under the CPC, the law says that every document for evidence is required. You are not told the truth. So these kind of things you can only harp on. And Supreme Court will say, what are you coming for? So please, bungalow owners, this case is, and this writ order is very bad. We guys were old grants. We were never converted into a new grant, whether it was a grant under GGO 179 or a grant under GGO 260. Please understand this. Thank you. Good day.